Ok, la pennetta è già collegata, per cui...
Ready? Welcome, everybody. If you just take your seats, we'll get underway. This day, the first full day of our medical ethics conference. Before we begin, we'd like to hear briefly from Ted Catchy from the University of Notre Dame. He's the inaugural academic director of the Notre Dame Rome Global Gateway, which is the facility that we're using today. He's a professor of Italian and the Albert J. and Helen M. Ravarino Family Director of Dante and Italian Studies at the University of Notre Dame. We are so pleased to be here in this beautiful space for this year's Medical Ethics Conference, and we're honored to have him join us today. Please help me welcome Ted Catchy.
Thank you. I want to thank Professor Carter Sneed for inviting me to say a brief word of welcome on behalf of the University of Notre Dame's Rome Global Gateway, and I want to thank Carter and the leadership team of the Center for Ethics and Culture for choosing the Rome Gateway as the site for the anniversary celebration of the 30th annual Notre Dame Medical Ethics Conference. As I'm sure you have already experienced in the brief time that you've been here, beginning with Mass at the Basilica of San Clemente yesterday or this morning's tour of ancient Roman landmarks, Rome is truly a very special, a really unique place to be. And it's a very special place for the University of Notre Dame, for the inspiring presence of the Holy See, and for the fact that Rome remains still the vital source or wellspring of the artistic, architectural, intellectual, and spiritual traditions of the West. The Notre Dame Gateway is located in the heart of what's known as the Celio neighborhood. That's the Celio Hill, one of the famed 7 hills of Rome. And you might want to visit the beautiful park on the hill, about a 5-minute walk up here, the Celimontana Park. The university really could not have chosen a better location for its global gateway. It's in the midst of several of the most important monuments of early Christianity, including, besides the Lateran, Santo Stefano Rotondo, Santa Maria in Dominica, and the Basilica Santi Giovanni e Paolo, all within a 15-minute walk from here. And just up the road from here, at 6 p.m. each evening, you can hear the cloistered Augustinian nuns sing the Vespers in the medieval Basilica of Santi Quattro Coronati that originally dates from the 5th century. To hear the Vespers sung in Santi Quattro is to enter another dimension, but Rome is like that, as you know. As a Catholic academic community of higher learning, Notre Dame has special reasons to be here in Rome. As you may know, the University School of Architecture has been present in the Eternal City for nearly 50 years. Undergraduate students in the school spend their entire 3rd year of study in Rome as a required part of their curriculum. More recently, the university has established a global gateway here, which I have the privilege to lead, and which aspires to establish a multidisciplinary center for research and education in Rome that will advance Notre Dame's reputation for scholarly and educational excellence and its Catholic mission. For these reasons, the Rome Gateway is pleased and honored to host the 30th Annual Medical Ethics Conference of the Center for Ethics and Culture, one of Notre Dame's key centers for international promotion of faith, service, and learning. And we bid a warm welcome to the international and interdisciplinary array of scholars and professionals in the field of medical ethics that the center has brought together here to discuss the most important ethical issues in medicine today. We hope the beautiful facilities and the excellent staff of the Gateway will serve you well in your work and that you will enjoy the neighborhood. And I must compliment Carter and his planning committee that he's left you a very good amount of space in the program to actually enjoy the city. And I wish more colleagues would have the foresight in their planning to do that. On behalf of the Gateway, and the staff, we wish you all the best and success in the important work that you'll be undertaking in these days. Thank you.
Thank you very much, Ted. It's a great pleasure of mine to introduce our speaker, our primary speaker today, which is a friend of mine for over 10 years now. His name is Andrea Rovagnati. I met Andrea for the first time in 2005 when he was a research scholar at the University of Notre Dame. We've been friends ever since. Our family and his family, our oldest children are exactly the same age. My 10-year-old's oldest friend is Giacomo Rovagnati, and they only recently have been able to actually speak to each other because they don't speak the same language. They spoke the same language when they were 5 months old, but then there was a divergence. Andrea is one of the most exciting emerging scholars of constitutional law in Italy. He received both his JD and PhD from the University of Milan, where he is now an assistant professor of constitutional law. In 2013, Andrea and his family returned to Notre Dame when he served as the Center for Ethics and Culture's Miser Fellow. While he was at the center, he worked on a book manuscript comparing the law of healthcare in the United States and the European Union. He has written 2 books on the nature of social rights and Italian judiciary as part of the European judiciary, in addition to numerous publications regarding areas of law, healthcare, immigration, and all the normative goods that underlie those different fields of law. Today, Andrea will speak on public access to experimental treatment and its legal limits, the Italian case. Please welcome Professor Andrea Rovagnati.
Thank you, Carter, and thank you, the Center, for your invitation. To introduce today's topic, I like to start from a recent story which happened in the US and may be familiar to many of you. I don't want to afflict you with my exotic Italian accent since the beginning of my presentation. It would be a really unjustified attempt to extend an unpleasant experimental treatment. So I basically asked Carter to read it on my behalf.
This is just a very brief vignette that will frame Professor Rovagnati's remarks.
Exactly.
Josh Hardy, an 8-year-old from Fredericksburg, Virginia, was diagnosed with tumors on both kidneys when he was 9 months old. Over time, the aggressive treatments weakened his immune system and resulted in a bone marrow failure disorder called myelodysplastic syndromes, or MDS. To combat the MDS, doctors gave Josh a bone marrow transplant, but he developed a viral infection soon after. After attempts to clear up his infection began to damage Josh's kidneys, his doctor appealed to Chimerix to release, that's a pharmaceutical company, to release its experimental antiviral drug, Brincidovor, this is the first time I've seen this word. It's not even English. Brincidofovir, I refer to it as CMX-001, which is its generic name, to treat him. When the company denied the request, Josh's family and friends initiated a campaign on Facebook, Twitter, and in the press. Eventually, Chimerix set up a new clinical trial for the drug and made Josh patient 1. After the first dose in March, his condition improved. Josh has to get his strength back and suffers from gastrointestinal and other issues, but the infection is gone, and he is expected to make a full recovery.
Well, dramatic health situations such as the one of Josh are very common all around the world in every time. And the decision of making available new investigational drugs for therapeutic use creates ethical dilemmas for all the subjects who are involved in the process, for patients and their families, as well as for the society as a whole, for physicians, for pharmaceutical companies, for political and technical bodies, as well for criminal and civil judges. Several questions arise. I'm going to read these questions, and after that, I like to invite you to take a few minutes, just a moment, to think how you really would answer them. Is it fair to entitle people to a right to try? It has the right to access experimental drugs whose safety and efficacy have yet to be determined. Is there a moral obligation to recognize such a right when experimental drugs have been deemed safe but not yet efficacious? Does a patient's right to treatment based on his or her autonomous decision-making ability supersede a pharmaceutical company's ethical responsibility to develop and market safe and effective products as fast as possible? To what extent do physicians have a moral duty to do whatever they can in order to save their patients? What should be the physician's accountability if adverse events happen to our patients treated with an investigational use of drugs beyond a clinical trial process? Seriously ill patients, may they be able to provide consent that is truly informed when receiving a medicinal product under an early access program? How can equity in distribution of unapproved drugs be assured when they are made available outside of clinical trials? Who covers the expense? Should the answer to these inquiries be different if the number of people affected by serious disease, maybe infectious disease, is very large? My hope was to give you an handout, but I'm from Italy, and so Italians always arrive late. Sorry about that. Difficult questions, right? First, these questions require us to consider how we truly conceive ourselves, our body, our willingness to interfere with the natural course of our life. Second, they demand us to think about what should be a fair relation between law on the one hand and science on the other hand. Third, the questions also ask us to reflect on the proper role of the legislative, executive, and judiciary branches in order to deal with situations such as the one of Josh. Well, generally speaking, each political community answers to the questions listed in the handout and that you could read. In doing so, they provide a response to the three levels of problems I mentioned before. What I intend to do today is to explain Italy's solutions in cases patients with serious disease or otherwise life-threatening conditions do not have satisfactory alternative therapy. In other words, someone like our Josh. My presentation will be divided in two parts. The first part will focus on the legal framework of the compassionate use of drugs that are in the process of being tested for safety and efficacy. The second part describes the jurisprudence of three courts called to protect the relevant rights and liberties that are embodied in the Italian Constitution, in the European Union Charter of Fundamental Rights, and in the European Convention of Human Rights. Finally, I'll conclude with a short consideration that I hope will be useful to start a conversation. Because Josh's case is probably, maybe, more familiar to you, I will use it as a model to illustrate how similar cases are addressed by the Italian legal system. Italy, as well as many other European Union member states, has a system meant to help patients like Josh access investigational new drugs, IND, I think you call IND them, outside of clinical trials. For a long time, clinical practices involving the use of new drugs under pharmacological experimentation were based exclusively on the principles delineated by the Medical Ethics Code. In Italy, under the code provisions, physicians have several duties to inform the patient about the diagnosis, the prognosis, and the therapeutic perspective and their consequences, to foster the best compliance to the therapeutic proposals whenever the limits of the existing medical knowledge were acknowledged, to propose to the patient treatments for which there is an appropriate scientific rationale, and to receive the patient express consent. In the mid-90s, the Italian legislature passed the law establishing compassionate use programs. It was an exceptional event, not only for Italy, but also for Europe. If I'm not mistaken, at that time, only French had already adopted an analogous legislation, and until 2004, no other European Union country has created a compassionate use program. In short, the statute is called the statute number 648, declares that patients who have no satisfactory alternative available can have free access to new drugs submitted to clinical trials, provided that those drugs are included in a special list provided by AIFA. AIFA is the Italian agency equivalent to the US Federal Drug Administration, AIFA. In other words, according to that legislative act, if a patient like Josh needs an investigational new drug that is included in the compassionate use list, the expenses will be covered by the state. I think a clarification is needed here if we want to understand the importance of the regulation we are considering. Don't forget that Italy has a universal healthcare system. Since the late 70s, the Italian national health system has offered inexpensive healthcare to all Italian citizens. So inpatient treatments that are covered include tests, medications, surgeries during hospitalization, family doctor visits, medical assistance provided by pediatricians and other specialists. The national health system is also responsible for drugs and medicines, and in principle, it covers their costs. With this in mind, let's go back to the legislation on compassionate use program. In the first moment, AIFA was free to choose how to exercise its delegated power. The only constraint imposed by the law was with respect to the budget. So AIFA couldn't put all those drugs unapproved in the list, but AIFA needed to respect the budget. However, only a few years later, the legislature has prohibited the insertion in the compassionate use list of medicines which do not have yet positive results from phase 2 clinical trials. In my opinion, this last legislative act, which was set up in 1998, makes clear the main reason for the creation of compassionate use programs in Italy. The necessity to prevent a violation of equality in access to treatments between two categories of patients. Let's assume that our Josh needs approved drugs. In that case, he can have them in our system, and he can have them for free. If instead Josh needs to access new drugs that, though probably safe and effective, are still in the marketing authorization process, the state will not be responsible for the expenses. This does not mean that Josh is precluded from accessing unapproved drugs outside the compassionate use programs. He may do that through a different route, called compassionate use on individual basis. However, note that compassionate use on individual basis is highly problematic because a physician would supply new medical products having limited evidences of their efficacy and safety. Clinical trials on these drugs, in fact, are still ongoing. The issue of the use of unapproved drugs, given its nature, which is basically experimental nature, although the purpose is therapeutic or diagnostic, has always been perceived as a problem. In spite of this, the modern physicians have felt free and actually have been considered totally free by the Italian public authorities until 2003 to request from manufacturers a supply of promising medicines to be used for patients under their direct responsibility. Only in 2003, as I said, the Ministry of Health was finally able to, to adopt a new regulation governing cases such as the death of Josh. The decree May 8, 2003 regulated the matter in this way. First, the physician makes the request for compassionate use medicine to the pharmaceutical company. The pharmaceutical company is free to accept or reject the request, and generally speaking, please note that pharmaceutical companies have no legal or regulatory obligation to provide access to unapproved treatments on the ground of compassionate use. If the company is willing to supply the experimental medicine, it drafts a clinical protocol that the physician should follow in the treatment. The physician submits the protocol to an independent ethics commission to obtain the authorization to start the treatment, and to this end, the following criteria should be fulfilled. You can read it. This is my translation, so maybe I hope that you can understand it. I go on to describe the procedure. After the Ethics Commission authorized the compassionate use treatment, the pharmaceutical company can provide the medicine for the compassionate use, and it must do that for free. The physicians assume the responsibility of the administration of the experimental product to patients. Well, I hope that notwithstanding my pronunciation and my speaking, the different legal regulation of access to not licensed medicines on a named patient basis, from that granted on compassionate use program, catch your eye. Through compassionate use program, as I already said, the Italian government made the effort to make available medicines that have already showed their safety and efficacy for target people, having similar condition of patients for whom there are not satisfactory alternative therapies. By choosing to regulate the therapeutic availability of experimental drugs on individual basis, the task of the government was different and more challenging. The government, indeed, was called to make an evaluation and establish a hierarchy of several ethically problematic interests. First, a decision needed to be made on the legal acceptability of the patient's moral claim to pursue the preservation of their own lives, if the case, even by putting their same own lives at risk. Second, physicians' position and interest needed to be considered. The burden of a terrible moral choice is up to them, but this may undermine their first medical duty, summarized in the principle to benefit or at least not to harm. Physicians know that the experimental treatment may have possible benefits to the patient, although these possible benefits are unproven, or at least not proven in the manner the regulatory body requires. Physicians know also that experimental treatment may determine an aggravation of the health status of the patient, or even cause his or her death. So physicians have the moral responsibility of opting to treat seriously ill patients under emergency use provisions, but what should be their legal accountability? Third, the legislator was asked to take into account the interests and needs of the manufacturers and their employees. Attempts to help individuals in immediate need may place at risk the pursuit of evidence-based regulatory approval that will make a product available as quickly as possible to the largest number of affected and soon to be affected individuals. Eventually, the legislator regulated what happens in the gray areas of clinical practice existing between the pharmacological experimentation of drugs and their proper use on market after registration. He had to deal with the interest of the whole society for a long-standing and effective research and clinical trial systems through which diagnostic and therapeutic intervention are proven effective and safe. Now, how has the Italian legislator squared the circle? Very briefly, by denying, first of all, that seriously ill patients are entitled to a right to try these drugs. The Italian legislature has negated that physicians are free to try whatever they think is appropriate to treat patients having a serious disease or a rare disease or otherwise a life-threatening condition. Keep in mind that what I said, that the law requires physicians' decisions both to be endorsed by pharmaceutical company and to be approved by ethical commissions. And don't forget that in order to gain those supports, physicians must rely on solid scientific justifications. Moreover, notwithstanding the presence of the informed consent of the patient and the authorization of the ethical commission, Under the Italian legislation, physicians prescribing a new investigational drug may be found negligent and liable for harm by accusation of malpractice. We don't have time to stay on this issue, which is very complex. Again, according to the legal framework I described, government or some other funding agency do not assume the financial burden of drugs that are still under investigation. Their costs rest on pharmaceutical companies. Finally, the Italian legislature has denied that pharmaceutical companies have a legal obligation to provide the new medicinal products. If pharmaceutical companies do not have enough interest to allow the access to those products, patients can do nothing but ask for their compassion. In that way, the legislation makes clear that the primary interest of the society is the development of evidence-based medicine, and that the drug approval process charged with ensuring safe and effective medicines is the way to follow. Obviously, it would be naive to think that ethical problems disappear under the described legal framework. They are not. And maybe, if you want, we can go back on these open issues after the coffee break. It's time now to turn to the second section of my presentation. So, given the described legal framework, one would imagine that a lively debate on its legitimacy among Italian lawyers, political scientists, politicians, physicians, patient organizations have taken place. But none of this has happened in Italy. I'm not in the position to tell the reasons of such silence. Rather, I want to point out that the lack of political discussion is quite surprising if one considers that the legislation I described affects freedoms, rights, duties, and powers. They should be deemed significant for individuals as well as for the whole community to be formally recognized in the Italian Constitution. I wrote some of the Italian Constitution relevant provision. Article 32 of the Constitution confers the power to protect public health to the Republic. It has to public institutions and delegated subjects. Have you read it? Okay. Whenever I can, I don't speak, and I leave the written text speak on behalf of me. Article 33. Article 41, private economic initiative is free. The assertion of the freedom of private economic enterprise expressed in this article has been deemed even more important when a private economic enterprise is in the medical field. And then finally, in recent years, the Constitutional Court has also recognized the patient's constitutional right to consent to medical treatments by deriving it from Article 2, 13, and 32 of the Constitution. This happened with this decision, where the Constitutional Court declared patients must receive appropriate information on the nature of the course of treatment and its possible developments, and on eventual alternative therapies. The information must be exhaustive so that patients are able to freely and consciously exercise their right to consent to medical treatments and their right of self-determination. So, it is quite remarkable how many Italian constitution provisions are significant when one deals with the compassionate use of medicines issues, isn't it? However, as I said, there has been no public discussion on the legal limits established in the area of use unlicensed drugs for therapeutic purposes. One may suppose that there have been at least some judicial judgment on cases involving either patients who weren't treated with experimental medicinal product as they wished to, or physicians who didn't receive the authorization to administer new investigational drugs to their patient by way of compassionate use, or yet pharmaceutical companies which have provided the drugs outside the clinical trials that then turn out to be harmful or fatal. The truth is that there have been no rulings in the last decades based on the already mentioned constitutional principles. The Constitutional Court, which is the only judicial body that has the power to declare a law unconstitutional in the Italian judicial system, has delivered no judgment on the system of access to experimental drugs since 1956, when it was set up. I don't know, may this depend on the special characteristic of the judicial review of legislation system set up in Italy? I'm inclined to not to think that the reason is there. Notwithstanding how the judicial review of legislation system works in Italy, we have had some relevant decision on the Constitutional Court in other fields of the experimental treatments, such as that of off-label use, drug, or that of use of advanced therapies. So therapies implying the use of cells, stems. Is that because Josh will to be treated with experimental drugs has always been met? I don't know. Data on the consistency of the phenomenon we are dealing with are not available. I don't know how it is in the US. Here in Italy, that's it. It is in this way. And please note that the absence of judgments on the constitutionality of the legal framework of the therapeutic use of experimental drugs has not been just a trait of the jurisprudence of the Italian court. The latter has been in good company. As some of you know, a Bill of Rights was drafted within the European Union legal order in 2000. The Charter for Fundamental Rights, this is the name of the document, has become legally binding across the EU when the Lisbon Treaty entered into force in December 2009. If you read the article of the EU Charter, you can find many provisions of interest. For example, Article 3, which declares the right to the integrity of the person. Or Article 13, which again regards the freedom of the arts and science. Or Article 35, which declares that everybody has the right of access to preventive health care and the right to benefit from medical treatment under the condition established by national laws and practices, assuring at the same time that a high level of human health protection shall be ensured in the definition and implementation of all the Union's policies and activities. Well, I think that it's not necessary here to explain how the constitutional interdependency living in the European continent works. Let's put it simply. The EU chart complements but does not replace national constitutional system in areas over which the EU has a competence. Aside those areas, the Charter is not legally binding, and the protection of fundamental rights is reserved to member states and their constitutional courts. This is exactly the case of compassionate use. It is a widespread recognition that in the last 20 years, the EU has become an all-purposes organization that has a direct impact on the area of healthcare. But during that time frame, compassionate use of unlicensed drugs has been preserved in the domain of the member states. As a consequence, the European Court of Justice, which is the supreme legal authority within the Union institutional framework, has never been asked to evaluating the compatibility of EU or member states laws that regulate the use of new medical investigational, new medicine outside clinical trials, sorry. As I mentioned in my introduction, there is a third level of protection of fundamental human rights and liberties in Europe. I am referring to the protection offered by the European Convention on Human Rights. The Convention is applicable at national level. And it has been incorporated into the legislation of many of the member states, which have accepted to protect the rights defined in the Convention. Domestic authorities and especially national courts have to apply the Convention. If they don't, and the individual complain about the failure to protect their rights, the European Court of Human Rights may rule against the state. Well, the Convention includes, as you could read, the right to respect for private and family life. And I think it's not necessary to be a lawyer to understand that any restriction of the patient's autonomous decision-making ability may concern the right protected by Article 8. But again, quite surprisingly, the single most active and important rights protecting body in the world, we appeal at the European Court for Human Rights in this way. This court has examined the issue of access for terminally ill patients to unauthorized medicine for the first time only in a recent judgment delivered at the end of 2012. I don't know if you had the opportunity to read it. It was in the material book. What did the court say in that decision? The court observed a trend among European countries toward allowing, under exceptional conditions, the use of unauthorized medicine. However, the court found that this emerging consensus was not based on settled principles in the law of those countries, nor did it extend to the precise manner in which the use of such products should be regulated. For this reason, the court excluded the Bulgarian legislation by limiting the access to investigational medicines as violated the right for private life of the applicants. What's the consequence? Our judge cannot usefully invoke the mentioned decision in order to challenge the constitutionality of the national law on compassionate use on the ground that such a law violates the Article 8 of the Convention. So, I make some brief conclusions. At the beginning of my talk, I pointed out that therapies based on experimental drugs provoke three different level of questions. The first level deals with the ethical acceptability of The first level deals with the ethical acceptability of patient access to unapproved drugs for compassionate reasons and its limits. The second level regards the relation between law on the one hand and science on the other. Finally, as I said, the phenomenon we have considered induce us to reflect on the proper role of the legislative, executive, and judiciary branches in order to deal with situations such as the one of Josh. How has the Italian system addressed those questions? I would like to answer starting from the last question on the role of the branches of a government on this matter. Both the legislative branch and the executive branch have been the principal decision makers so far, whereas the contribution of the judiciary branch has been insignificant, in particular that of the courts, which are guarantors of the fundamental rights and liberties. Is this a satisfying equilibrium? Those who are in favor of the existing legislative framework will probably say yes. However, it may be not for those who consider that framework illegitimate. The latter will probably be inclined to seek the alliance of the courts in order to change that framework. This is what exactly has happened in other two segments of experimental therapies, that of the off-label use and that of the so-called advanced therapies. Lower level judges have allowed access to these therapies as a way to guarantee what they have called the patient's constitutional right to healthcare. Second point, concerning the relationship between law and science, we can say that the Italian laws tend to avoid interfering with science. The political branches supervise the work of doctors and clinical researchers. Their work, however, needs to be based on evaluations acknowledged by the scientific community. Ultimately, physicians and researchers will decide whether offer or not the patient's treatments which lack scientific evidence. I don't know, do you see any deficiency to such approach? I would like to discuss with you about it. And I should face now the first issue. I confess that the ethical acceptability of access to a new experimental drug is something I need to reflect more. But I hope that we can continue to do that together, and I'm really grateful to have the opportunity to discuss it with you. Thank you, and sorry for my English.
Okay, that was a lot of very clear information about a different system of government and the approach that they take to the question of unapproved drugs for people who are in very desperate circumstances. Why don't we go and adjourn to our breakout sessions? Why don't you come back in a half an hour, discuss amongst yourselves for a half an hour, come back at 25 after 3. We'll have time for about 10 minutes of questions, 15 minutes of questions, and then we'll continue our conversation during the coffee break. So Laura's going to tell you where to go now.
Yep. Hi, I'm Laura Nash. For those of you who I haven't met, I'm the events planner at the Center for Ethics and Culture, so please feel free to come up and introduce yourselves throughout the week. I look forward to meeting you all. So as Carter said, we're now going to break into our small groups. The small groups are listed and detailed in your packets in the folder that you received yesterday at registration. So each of you will change groups during each session, so be sure to pay attention to that. For the second session, which is the session we just had, we have students in the back who will lead you to the group rooms, and they'll be able to, throughout the week, direct you to the rooms should you need any help. So they'll just be in the back, and as Carter said, we'll come back here for questions afterwards. Thanks.
perfectly clear. It was perfectly clear. I'm not kidding. I'm not just saying it. No, I'm being story. Okay, if everyone could please take your seats, we're going to have a few minutes for question, about 10 minutes for question. I'll give you a few more seconds to find your seats. You want me to keep the queue? I'll keep the queue. Okay. I'll keep the queue.
What do we do?
I'll just call on people, and then they ask you a question, and you respond.
Okay.
Okay, we're going to go ahead and get started with the questions. I will keep the queue. And our first question will come from this gentleman. Please identify yourself, sir. Bob Scott. Dr. Scott. Great. Dr. Scott will begin with the first question.
On one of your slides,
Actually, if you could just wait for the microphone. Here comes the microphone.
sorry.
Yep.
On one of the slides in the presentation, there was a list of fundamental human rights as recognized by the European Union. And one of those lines seemed to be an anti-eugenics line. And that doesn't seem to jive very well with just last year, I think, at this conference, there was a long session about, I think, in the Scandinavian countries, how they're aiming to wipe out Down syndrome, in the next so many decades by very, very aggressive selection. And is that statement pretty much, ignored? And how much of the rest of the fundamental human rights statements are similarly ignored?
Thank you for your question. Basically, what I said about just a moment, about the new investigational drug and the place that the judgments that haven't been delivered by the international European courts as well as by our constitutional courts can be extended to that area. So as well as in the area we focused, also in that area, so the area of cloning and advanced therapies and so on, European Union basically doesn't have competence. So it tries to have, it passes legislation, but it's not a binding legislation. And for this reason, the provisions of the Charter don't apply. So they are not binding for the national bodies and courts.
So yeah, just to add to that, so in response to your question, that provision has no meaning for the national laws that seek to eliminate certain kinds of populations because of disfavored genetic characteristics. So that language, which sounds like good protective language, doesn't have any traction in the various individual states. Jeff Bishop. Yes, please.
In the U.S., there is an increasing drive. There's kind of an intersection of quality improvement and making sure that everything we do in the clinical arena is measured so that you essentially put everybody on something equivalent to a clinical trial because you're constantly gathering information. So there's the quality improvement side of medicine that's intersecting with the research ethics side of medicine, such that some people have said that every medication, everything should be on equivalent to like a clinical trial. So we are constantly comparing and doing statistical comparisons. And so I wonder if that sort of move, and this happens a lot in children's hospitals where virtually every drug that is given is on some sort of protocol. So I guess the question is, moving in that direction with the quality improvement piece of this kind of coming in everywhere, is this going to move us away from even needing this concept of compassionate use? In that everything's going to be constantly monitored.
Can I ask a clarifying question, Jeff? Who is requiring the kind of follow-up and monitoring that you're describing? Is it internal to the health entities?
Yes.
It's not coming to... Oh, the Affordable Care Act is requiring
Yeah.
that. So it's actually federal regulations that are driving this obligation to keep this record keeping for
That's
quality
right.
assurance?
That's right. Yep.
And so the question is that... Yeah, go ahead.
Well, I think that there is a similar development in our country, in Europe, basically. But the problem is that some therapeutic activities are intrinsically experimental. And so, in some sense, you cannot really collect data. You cannot make statistics. I'm not an expert of oncological treatments, but for sure, in Italy, more than 50% of the cases are treated with off-label use. And in the case of children, this level is higher. And basically, oncologist says, well, you know, we need to try a route to save those people, and we cannot base on evidence. And at the same time, we don't want to be asked to give information because in some sense, we are experiencing something that can bring us before courts if something bad happens. So I don't know if I answer your question.
Yes, so tell me your name. Okay, great. Emily?
My group had a question about the pharmaceutical companies, and we were just wondering, like, what is their incentive to participate in, like, these experimental drug trials? Because, say, there was an adverse effect, it'd be very public and could interfere with future marketing of the drug. And in addition, do the pharmaceutical companies assume any liability if there is an adverse reaction?
Well, yes. Good. Thank you for your question. Both physicians and pharmaceutical companies are responsible legally if something happened to patient, and in Italy they are responsible both from a civil and criminal point of view. So it's not just that maybe they can be called to give money to the patient or their family, but also they can be sued before a criminal court. And sorry, the first question.
What's the incentive? Why would they participate in this?
What's this? Sorry.
Incentive. Why would a pharmaceutical company want to participate in this compassionate use program when they have to bear the costs and there are these possible risks of adverse results?
Well, I don't know. I wish I can because I don't know. Maybe I really don't know. But I think that you have the same question for the experience for your system. Why in the U.S. Pharmaceutical companies sometimes allow to provide that kind of new medicine to Josh? Why not? In my opinion, here in Italy, it's easier to do that if the media, in some sense, accept to make your case a national case. And we have had 2 or 3 of this situation, not with new investigational drugs, but as I was saying, in cases of off-label use drug and advanced therapies. Maybe some of you have heard of the stamina case. It's a case involving advanced therapies. And, for 2 years, I guess 200 courts in Italy were pressed by basically the media to allow patients to access to those kind of treatments without having any evidence about their safety and effectiveness. So I don't know. Obviously, if pharmaceutical companies supply the medicine, they may be responsible. On the other hand, they can improve their knowledge of the effectiveness and safeness of what they are doing. So,
Mark, to this.
Is this on? Yeah. I can answer the clinical side of that question a little bit. I'm Mark Harrison. I'm Donna's husband. I'm an infectious disease specialist in Michigan, did a lot of phase 2 and 3 clinical trials in the AIDS era, not so much now. But first thing is, in the United States, compassionate use sort of morphed into, under this media and societal pressure, into what was called Subpart H, or you'd know it as fast track for AIDS drugs, and it actually spread out into non-AIDS drugs. But there is some reason to do compassionate use trials in the AIDS era, and still a lot of trials as they go from, or a lot of NDAs as they go from phase 1 and 2 to phase 3, they'll open up a compassionate use access program in the States and sometimes elsewhere that allows them to put true compassionate use cases in the toxicity database. Doesn't say anything about interpreting efficacy usually, but it sort of adds to the 1 and 2 phase safety data. So they get something out of that. Pharma is out to make money, but they only make money if they really cure people and to have some efficacy, right? So they are looking for candidates to help them down that road. So that's why they can do it free, because they do care, believe it or not, and they do get a little bit of data out of it. There was a second question in besides why they do it. They're legal. They are legally responsible. In fact, if you've ever seen a phase 2 or 3 informed consent, it's about a 20 or 30-page document that the patient signs and an independent observer attests to, okay? And in that it says explicitly who's going to pay for what. It is a legal binding contract. It's not just a whole process of patient-physician relationship and law. There's contract law entangled in it too. So, for instance, in a phase 3 trial where you know a lot about the drug, you know a lot about the patient and the disease, you're pretty much going in an open-eyed. It says in it, if you have a major side effect, the pharmaceutical will pay for the cost of that care. In fact, and that's one of the main drivers why, if you've ever done phase 3 trials, one of the hugest no-nos you ever can do in a clinical trial is to enroll pregnant women by accident, because then care becomes 70 years of cost. Okay, so they do explicitly state their responsibilities in phase 2 and 3, and I would imagine under compassionate use they would also outline that. So.
Did you want to say anything in response to that? So we are actually, it turns out we're a little behind schedule, so I think we should go ahead and take our coffee break. There are folks that remain in the queue, and I apologize for that, but we can continue our conversation out in the refreshment area. And I should have said this at the outset of the event, by the way. We have a lot of folks who are joining us who have been coming to this conference for many, many years, some even from the very beginning. For those of you who are new, though, I just wanted to underscore that the breakout sessions are really an essential piece of what we're doing, and we're excited that you all, but we want you to understand that those are meant to be discussion periods where you can have free-wheeling discussion amongst yourselves. We have a lecture portion, then we have a discussion portion. I'm sure that was self-evident and I'm sure that don't even need to make this announcement, but for the sake of the people who are new. And then finally, there's good news. Notre Dame won its HHS lawsuit in the Supreme Court today. They won in the sense that the court granted our application for certiorari. They vacated what the Seventh Circuit did, and they remanded it to the Seventh Circuit to reconsider our case in light of Hobby Lobby. So it's a temporary win. Hopefully it'll be a permanent win.